Good afternoon, everybody, and thank you for joining us for our outreach session for the new custody rules and the results of the CRM2 sweep. Your presenters today are going to be Leanne Ronan, myself. I'm legal counsel in the Compliance and Registrant Regulation branch, and my colleague Scott Lasky, who's a senior accountant in the same branch. And here's our usual disclaimer, part of which essentially is us telling you that the views that we're expressing today in this presentation are our personal views and do not necessarily represent the views of the Ontario Securities Commission or any of its other staff. So today's agenda, I'm going to be discussing the new custody rules and some frequently asked questions that we've received. I expect my presentation will be approximately 50 minutes, and Scott will discuss the results of the recent CRM2 compliance sweep, and he expects that his presentation will be approximately 25 minutes. We're going to try to answer as many questions on our presentations as time permits, and for today's webinar, please submit your questions electronically, and we will address them at the end. We suggest submitting your questions throughout our presentation rather than waiting for the Q&A session at the end. This will just allow us more time to consider and review the questions. Hope everybody is very excited. This is going to be very scintillating. The overview of the new custody rules and frequently asked questions. I know, I'm sure I'm the only one who's really excited about these rules, probably because I drafted them. So as everybody knows, the rules came into force on July 4th of this year. And I'm going to be talking to you a little bit about what the purpose and goals were for those rules, what the key elements are of the rules, and I'm going to highlight some of the inquiries that we've received to date. So the purpose and goals of our amendments were to enhance custody requirements applicable to registered advisors, dealers, and investment fund managers. We also wanted to mitigate intermediary risks when registered firms are involved in custody and enhance the protection of client assets. In respect of intermediary risks, we're talking about when somebody is in between the client and the registered firm. And so one of the goals was to make sure that that entity in between those two was a reputable custodian, and also to limit access to client assets that's associated with having a related custodian or self-custody. We also were only aiming to codify existing custodial best practices, and so in this regard, we were not expecting there to be any significant impact to the industry. By having these new rules, we also were going to increase consistency in business practices and also create a strong regulatory tool for ourselves against inappropriate practices. For us, that means being able to show a specific contravention of a securities rule if there's something that's going on that we don't think is a best practice. And we also wanted to give ourselves specific requirements against which to assess compliance. For example, who can act as a custodian for securities and cash of a client or fund, and how these securities and cash should be held by the custodian. And finally, these rules also provided our ability to be more aligned with international regulatory standards. So now I'm going to discuss the key elements of the new custody rules, of which there are 7. So the first is to require disclosure to clients regarding where and how assets are held or accessed, and also any associated risks and benefits in respect of this type of custody or access. Secondly, we generally require the use of a Canadian custodian, which is defined in National Instrument 31103. And thirdly, we will permit a foreign custodian to custody these assets, but only if it's more beneficial to the client. And this concept is discussed a little bit more in the companion policy to 31103. Fourth, we wanted to restrict registered firms from acting as the custodian or a sub-custodian for clients with very limited exceptions. So for example, the type of registered firm that could self-custody or be a sub-custodian would be a subset of the Canadian custodian definition. So a bank, a trust company, an investment dealer that's a member of IROC who's permitted by the rules of IROC to custody client assets. And also we would need there to be a system of controls and supervision in place to manage the custody-related risks to the client or the fund. Fifth, we also wanted to restrict the use of a custodian that was not functionally independent of the registered firm, with, again, very limited exceptions. This functionally independent concept is also described in our companion policy to National Instrument 31103. And essentially, it means that we're looking for there to be separate mind and management between the registered firm and the custodian, so that it truly seems that the custodian is operating independently. We also expect that the custodial activities are going to be performed by personnel that are separate from or independent from the personnel of the registered firm. And we're also going to be expecting to see systems and controls in place to ensure the independence of the personnel that are performing the custodial function. I think it's very important to note, because this question has come up from a number of sources, that when we drafted these provisions, we did expect that most bank-owned registered firms would be functionally independent from their affiliated custodians. Number 6. So generally, except for bulk trading and certain cash-only accounts, we require client securities and cash to be held in an account of the client or the fund. For example, this means that the custodian's records must show who the beneficial owner is for the relevant securities and cash. And the beneficial owner that should be on the records of the custodian should be the client or the investment fund. Number 7, the last element. So for assets that are not securities and cash, so for example, gold bullion or uranium, and also for assets that are not subject to the custody requirements in section 14.5.2 of 31103. Essentially, these are the exceptions to the custody rules, which I'm going to discuss with you or outline for you momentarily. So these assets that are not securities or cash, or assets that are exempt from the custody rules, they're still subject to what used to just be our original segregation and holding requirements. And essentially, these are holding the assets separate and apart from the registered firm's own property, in trust for the client or investment fund, and for cash in a designated trust account with a Canadian custodian or a Canadian financial institution, or a foreign custodian if it's more beneficial for the client or the investment fund. This is the baseline requirement that also aligns with the Bankruptcy and Insolvency Act in order to ensure that customer assets get pooled as customer assets so that they are ahead of creditors if there was to be a bankruptcy or an insolvency. So now I'm going to discuss with you the exceptions that we've included in National Instrument 31103 respecting these custodial related rules. There are 10 exceptions, and I'm going to go through each of them with you now. The first is that investment dealer firms that are members of the Investment Industry Regulatory Organization of Canada, IROC, and mutual fund dealer firms that are members of the Mutual Fund Dealers Association are exempt from the custody rules, provided that they comply with their self-regulatory organization's custody rules. Secondly, registered firms are permitted in very limited circumstances to self-custody or act as sub-custodian. And as I mentioned before, those very limited circumstances are for banks, trust companies, investment dealer firms that are members of IROC that have a system of controls in place in order to mitigate risks to clients. Third, investment funds that are subject to National Instrument 81102 or National Instrument 41101, those funds are also exempt from our requirements because they're subject to a separate regime, and we wanted to make sure, like our goal in making the custody amendments was to ensure that all investment funds, one element, would be subject to robust custody requirements. Because 81102 and 41101 have their own robust requirements, we weren't going to make any changes there, but we did want to make sure that these funds for prospectus exempt products also had a robust regime. And fourth, customer collateral subject to custodial requirements under National Instrument 94-102. That's also exempt from our custody rules in 31-103 because, again, there's a separate regime covering those assets. The fifth exception. This is essentially for client name securities or for certain units of funds. And the caveat is that in order to be exempt from the custody requirements, those securities have to be recorded only in the name of the client or the fund on the books of the issuer or the issuer's transfer agent. And I've had a number of inquiries in respect of that language. As part of the FAQ, I'll discuss that a little bit later in this presentation. Number 6, we've also given an exemption for permitted clients that are not individuals and not funds, so that these permitted clients could decide that they wanted to use a custodian that may not meet the Canadian custodian or foreign custodian definition. They might even want to have certain assets held with their registered firm, and so they have an exemption. We made sure that we carved out funds because, of course, one of the goals of our amendments was to ensure that these prospectus exempt funds were subject to a robust regime, and so if we had not carved out funds, that would have not worked for what our goals were. So number 7, we also have an exception for mortgages. And the mortgage exception is also very similar to the client name fund unit exemption that we have. So essentially, mortgages don't have to be subject to our custody rules if the mortgage is registered in the name of the client or the investment fund as mortgagee, or in respect of syndicated mortgages, is registered in the name of each investor that is a mortgagee in respect of the mortgage. And so those two aspects of the mortgage exemption are essentially like a client name carve-out, but we also created for syndicated mortgages an additional carve-out that's more similar to Section 14.6 of 31-103. This is our catch-all version that adheres to the Bankruptcy and Insolvency Act requirements to keep customer assets in a pool above other creditors. And so this one allows the syndicated mortgage to be exempt from our rules if it's registered in the name of someone that's registered or licensed under Canadian mortgage brokerage, mortgage administrators, mortgage dealer legislation, if the mortgage is held in trust for the client or investment fund. So now we're on to exceptions 8 and 9. Both of these exceptions are really for non-Canadian custodians. So it essentially broadens for, in very limited circumstances, the types of foreign custodians that can hold certain assets for clients or investment funds. So now number 8 is cash to securities deposited with a dealer's margin for transactions outside of Canada involving certain cleared options or futures. And one portion of this exemption is that the dealer's records have to show the beneficial ownership of the assets is vested with the client or the investment fund. Number 9 is for cash or securities deposited as security in connection with a short sale of securities with a dealer outside of Canada. For both of these exemptions, this dealer has to be a member of a particular type of exchange, and that's outlined in our rules in 31-103. They have to be subject to a regulatory audit, and they have to have a net worth over $50 million. And both of these, because they are extensions in a very limited aspect of the foreign custodian definition, the foreign dealer has to be more beneficial to the client than using a Canadian dealer. And so lastly, the last exception is for cash and securities deposited with a client or funds counterparty where security interest has been granted in connection with a specified derivatives transaction. That's a term that's defined in National Instrument 81-102, and which we've incorporated by reference into National Instrument 31-103. These are essentially cleared derivatives transactions. And again, the caveat here is that in order to rely on this exemption, the counterparty's records have to show that the beneficial ownership of the assets is vested in the client or the investment fund. So I think there are a few things that are worth noting about the new custody rules. The first is that the new rules apply to client securities and cash, not to client assets that are not securities and cash. So for the latter, for example, gold or uranium or platinum, we're keeping the original standard on segregation and holding in trust for the client as the minimum standard for these assets that are not cash or securities. And also, our rules differ from the 81-102 custodial requirements in a few respects. One of them is that certain IROC dealer member firms are able to meet our Canadian custodian definition, but they would not meet the requirements in 81-102. And also, we don't have a requirement to only use a single Canadian custodian. We do permit multiple custodians to be used, and they could be Canadian or they could be foreign as long as they meet our definitions. And finally, we do not govern who the sub-custodian can be in these arrangements, although we do have guidance in our companion policy to 31-103 in this regard. So I also thought that I would walk you through our guidance, because when we implemented these rules, we also included a fair amount of guidance in the companion policy to 31-103. So I will walk you through them. There are about 7 points that I'm going to cover in respect of the guidance. So the first is in respect of relationship disclosure information. And in our guidance to 31-103, we provide examples of risks that could that you might want to disclose to your clients. So for example, whether the custodian uses sub-custodians, whether the custodian used is not independent of the registered firm itself, or whether a foreign custodian is used. Secondly, we have guidance on the restriction on self-custody and the qualified custodian requirement, the requirement to use a qualified custodian. And so some of the things we highlight in the guidance is that cash and securities includes portfolio assets of a fund, and it also includes cash held by an investment fund manager for the investment in or on the redemption of securities of a fund, which is also known as cash in transit. We also confirm in the guidance that if you're interpreting the terms hold or held, you can look to the definition in section 14.14 sub 7 of National Instrument 31-103, which is part of the account statement section. And access includes the list in section 12.4 of the companion policy to 31-103. We also outline in this section some matters related to foreign custodians. So how we might typically expect foreign custodians to be used, and the risks that would generally be associated with their use. Of course, our lists are never all-encompassing, and so if there are more risks or benefits or permitted uses, obviously you can add to the list as need be. So the third aspect of the guidance that I'm going to discuss is the exemption from the self-custody and qualified custodian requirements. Sorry about that. And basically here we just outline that investment fund managers are deemed to have access to fund assets and therefore are not typically exempt from the custody rules. Number 4, we have a section on the prohibition on self-custody and the use of a custodian that's not functionally independent. In this section of the guidance, we set out the factors that we'd consider for a system of controls and supervision to manage the risks to a client. And these factors would include the segregation of duties between the custodial and other functions of the registered firm's functions, asset verification examination by a third party. We also include here how a firm might have access to client assets if the custodian's not functionally independent. And we let you know that this is set out in section 12.4 of the companion policy. And finally, in this part, we also talk about the relationship between a registered firm and a custodian that's not functionally independent. And we outline that this would cause a conflict of interest that must be managed or avoided by the registered firm. And in this regard, we point you back to our our general rules and guidance on conflicts of interest in Section 13.4 of National Instrument 31103 and the associated companion policy guidance. And so the fifth area of the guidance covers general prudent custodial practices. And here we outline that assets that are not cash and securities, again, example, gold bullion, uranium, platinum, something else not cash or securities, we're expecting firms to use their due skill, care, and diligence to select an expert custodian for these types of assets. Registered firms are also encouraged, are to encourage their clients or funds to confirm that they're receiving account statements from their custodians and, as applicable, to compare those statements to the statements they receive from a registered firm. Now, this aspect is something that I've received some questions on, and in the FAQ, I'm going to discuss how the guidance here in 31103 regarding clients receiving account statements and comparing them, how that interacts with our CSA staff notice on portfolio manager and dealer service arrangements. A hint is you can still use the CSA guidance on portfolio manager and dealer service arrangements, but we'll talk about that a little bit more shortly. In this section as well in the guidance, we also outline that firms are expected to reconcile on a regular basis their internal records against the custodian's records. Number 6. So custodial arrangements. Here in this guidance, we outline for investment fund managers that they are to use their due skill, care, and diligence to select a custodian and also to periodically review that custodian. These investment fund managers are expected to know the custodian's practices in respect of selecting and monitoring sub-custodians. And we're also expecting to see a written custodial agreement that includes certain terms. For example, the location of assets, the appointment of sub-custodians, the method of holding assets, the standard of care of the custodian, and the responsibility for loss. Now, for registered firms that are not investment fund managers, we acknowledge that these firms are not necessarily going to be party to the contract between, for example, the fund or their client and the custodian. However, because of the heightened relationship that these registered firms have, because they've directed or arranged with their client who the client's going to use as a custodian, or because they have access to the client's assets through the custodian, these firms are expected to understand the material terms of the custodial agreements of their clients and explain to clients the main purpose of the agreement. We also want these firms to alert clients to the use of sub-custodians. However, you don't have to talk about sub-custodians in depth. You can just alert your client so that they know that there's a risk, and if the client is concerned, you can direct them to speak directly with the custodian, who'll have more information. And lastly, in respect of the overview of the guidance, number 7, in respect of client and investment fund assets held by a registered firm and trust. This is Section 14.6 of National Instrument 31103 and our original standard prior to the new custody amendments. This has now become the minimum standard requirement, and as I've mentioned before, will apply to to assets that are not cash and securities or assets that have been carved out of the custody requirements and the exceptions that I discussed earlier. And we note that Section 14.6 of 31103 could apply to investment fund cash in transit that is often subject to these segregation and holding requirements. And although investment fund managers can outsource fund administration functions to service providers, including the trust accounting function, the investment fund manager must ensure that cash in transit is, at a minimum, held in a designated trust account at a qualified custodian or a Canadian financial institution. Investment fund managers are accountable for all outsourced functions and must ensure that the service provider has adequate controls. So I know this has all been fun and scintillating and exciting, but now to the meat of everything, the frequently asked questions, the part you've all been waiting for. I'm just trying to make it fun, guys. I'm sorry. I know that it's a lot to take. But I do have 7 frequently asked questions that have arisen, and I thought that you would at least find it interesting to talk about them. So That's why you're stuck with me for probably another 10 or 15 minutes before you get to hear Scott. And so I'm first going to, of the 7 common inquiries we've received, the first relates to relationship disclosure information. This is probably the area where we've had the most questions. The restriction on self-custody, the meaning of the terms direct or arrange and access, clarification regarding the use of the exemptions for 81102 and 41101 funds, clarification of the exemption that uses the term recorded only in the name of the client or investment fund, the application of the custody rules to non-resident registered firms and their foreign clients or funds, and lastly, the guidance regarding client statements and the interplay with the portfolio manager dealer service arrangement CSA guidance. Okay, so in respect of the relationship disclosure information, I'm just going to give you a little reminder that essentially our rules say that registered firms that hold or have access to client assets or direct or arrange custodial arrangements for clients must confirm where and how the client's assets are held and any related risks and benefits. And I remind you that we did add some guidance to the companion policy to 31103 in order to outline our expectations in respect of this relationship disclosure information. However, one of the questions that has come up is, why must a registered firm provide relationship disclosure information on the custodian? Because they themselves are not the custodian. And so what we've said to people who have asked this question is that from our perspective, the security of a client's portfolio is essential and a reputable custodian is of utmost importance. Often, a registered firm will require clients to use a particular custodian, including directing them to a particular custodian, just one, or it could be a list of custodians. And sometimes a registered firm will have access to the client's account. For example, they might be paying bills, or they might have a power of attorney. Also, for a portfolio manager, as an example, access would be more than just the ability to deduct their management fees alone. So we expect registered firms to have conducted due diligence on custodians. Essentially, these are the custodians who they, again, remember, recommend to their clients, or custodians where they have access to client assets. And so for these registered firms, they should have conducted due diligence on these custodians, and accordingly, they should be able to articulate the risks and benefits of using those custodians for their clients. We want clients to know who their custodian is and how their assets are being held. How safe is this method of holding client assets? How competent or reputable is the custodian? Is it even a qualified custodian? And where are the assets located? Are they inside Canada? Are they outside Canada? And as a reminder, this is relationship disclosure information. Registered firms must disclose the risks and benefits of the custodial arrangement as it relates to the relationship between the firm and the client. So you're not going to just be reiterating custodial related risks. You're going to look at the relationship that you have with your client, knowing their accounts, etc. And so, for example, one risk could be that the custodian engaged by the client is not a qualified custodian. Or another risk could be that a Canadian custodian has been chosen for a U.S. tax-advantaged account, which could create currency exchange implications. These are all things that you would know due to your relationship with the client. So as I just said, registered firms are not expected to replicate the custodian's disclosure. Registered firms can just direct clients to the custodian for further details in respect of custodial-related risks. And I've also had questions asking whether there's a prescribed form of disclosure, and no, there is not. Registered firms can decide on the form of disclosure themselves. They could integrate this disclosure in a way that they think is most valuable for clients and efficient for the firm. I've also received a number of inquiries regarding the depth or level of detail that's required for the relationship disclosure information. And the answer to that is it's going to depend on on which custodian's being used and the amount of influence that the registered firm has regarding choice of custodian or the firm's level of access to client assets. So the more limited the firm's ability to access client assets or direct the client to a custodian, the lighter the disclosure. If a Canadian custodian is used and the firm does not hold or access client securities in cash, this disclosure is likely to not be that significant. It's going to be fairly light. However, if a foreign custodian is used, then we would expect that there's likely going to be more disclosure related to risks and benefits, including, for example, it might be difficult to retrieve client assets in the bankruptcy of the foreign custodian. However, a benefit could be that there are tax benefits to holding assets with the foreign custodian. You're closer to the marketplace. There are U.S., for example, legal requirements, all of those things. A firm would typically be expected to discuss the risks and benefits related to their choice of custodian for their clients. Remember, you've chosen this custodian for your clients, or you've given them a list. And so this could include the results of your due diligence on when you made the list or when you decided you were going to choose that custodian for your firm and your clients. And because we've been asked a lot for examples of benefits and risks, I thought I would come up with some. Of course, there are many, many more, and it will be influenced by your specific arrangements and relationships with your own clients. But for example, some benefits could be your client is a Canadian custodian with assets located in Canada. Your client has expertise for your mix of investments that maybe they're foreign or domestic or plain vanilla or complex. The custodian is qualified to conduct this type of business. A foreign custodian is used for your U.S. tax advantage securities due to U.S. legal requirements. And then some examples of risks. These could be you use a Canadian custodian and you are acquiring foreign securities. This means that you are holding your securities further from the marketplace, and there's also exchange rate risk. Or your custodian uses sub-custodians to hold a portion of your assets. There may be risks and benefits associated with this practice, and we encourage you to speak directly with your custodian in this regard. Some additional risks that you might want to, if they're applicable to your relationship, that you could discuss with your client or disclose to your client, could be, as you are using a foreign custodian for your U.S. assets, you may have difficulty enforcing your legal rights or accessing your assets if the custodian becomes insolvent or bankrupt. Your custodian's not independent of the registered firm, and then you should explain whether this could allow the registered firm, you yourself, to access client funds, including how you could access those funds and what the implications could be for the client. Note, of course, when you're going through all these risks, you may want to explain, or going through the risks and benefits, you may want to explain to your clients why this custodian was chosen over another. You ultimately need to consider what else your client might need to know about why you direct your clients to this custodian, and that will inform your disclosure to your clients. So in respect of the restriction on self-custody, so registered firms are generally prohibited from acting as custodians or sub-custodians. That's just a reminder of what it says in the rules. And essentially what we did when we made this prohibition is we codified a current best practice, and we knew it would have a limited impact because we knew most of our registered firms were not acting as custodians or sub-custodians themselves. And of course, this is outside of IROC firms or MFDA firms because they have their own rules that deal with those sort of things. However, some exceptions where we might see a registered firm custodying some sort of client asset could be the documentation related to fund units, the ownership of fund units of your client names, certificates, share certificates, and mortgage documentation. These could be something that you might have in your office in a lockbox. So, who may self-custody client or fund assets? Well, as I've mentioned a couple times before in this presentation, there are limited exceptions for registered firms that are themselves banks or trust companies with $10 million in equity and investment dealer firms that are members of IIROC, provided they are permitted under the rules of IIROC to custody client assets. And these firms must have a system of controls and supervision in place to manage the risks to their clients or investment funds. And there's companion policy guidance on what that means. And so, yes, there could be an example of an investment dealer firm that's also registered as an investment fund manager who could potentially self-custody client or fund assets. So the next set of questions relate to the meaning of director, arrange, and access. So to start with director, arrange, this terminology includes telling your clients or funds who to use as a custodian, just one. We use X custodian. If you want to come and have me manage your money, you must use that custodian. Recommending one or more custodians, or even providing a list. However, directing or arranging excludes clients who choose their own custodian. So registered firms, however, if a client is choosing their own custodian, you should have documentation or records to confirm and show that clients did choose their own custodian of their own volition. Just so that if we come on a compliance review and you tell us this is the case because we see that they're not using a Canadian custodian or foreign custodian, then you'll have the documentation that can show us why, it's permissible in the circumstances. And it's this concept of director arrange that is not retroactive. In our notice we mentioned it's not retroactive. And this is because perhaps 10 or 15 years ago you started a relationship with a client, and at the time you directed the client to a particular custodian, but today that custodian may not meet our definitions of Canadian custodian or foreign custodian. So we're not saying that clients need to change their custodians if that relationship's been in place for the last 15 years, for example, just because they don't meet the new definitions. However, your relationship disclosure information should disclose this matter to your clients so that at a minimum they're aware that they're using a custodian that doesn't meet the set of custodians that the regulators have outlined as being the ones that we would generally find acceptable. And now for the meaning of access. Well, we just talked about the fact that it's not retroactive if your client chose a custodian or was directed to a custodian by you 15 years ago. However, access is an ongoing state of affairs. It's something that is in continuity. And so because of that, the custodial relationship has to comply with our custody rules. There's no retroactive notion in respect of access. And access includes the examples in section 12.4 of the companion policy to 31103. However, it excludes discretionary authority over clients or funds, cash or securities by itself, and it excludes the authority to debit client accounts to pay only for investment management fees. So now I'm going to move on to clarifying the 81102 and 41101 exceptions in the custody rules. We're getting really close, everyone, so please stay with me. I know that it's been a very, very long talk. So one of the questions I received is, for a portfolio manager, is this exemption available when the client is an 81102 fund? Oh, you know what, guys? I think I skipped something. Did I skip something? Yes, I did. Apologies. Okay. So for these 81102 and 41101 exceptions, I suppose that I should give you a reminder as to what they are. So the new custody rules do not apply to investment funds that are subject to National Instrument 81102 and 41101 because an alternative custodial regime applies. So, for example, an investment fund manager does not need to ensure that its public fund complies with the 31103 custody rules. Instead, it must continue to ensure that the fund complies with the 81102 or 41101 custody rules as applicable. And so our exceptions from the custody rules in paragraphs 14.5.2, sub 7, A and B, so basically the exceptions for 81102 funds and 41101 funds, are not exemptions from the self-custody prohibition in subsection 14.5.2 sub 1 of 31103. Instead, the question came in, so for a portfolio manager, is this exemption available when the client is an 81102 fund or when the client is holding units of an 81102 fund, or both? And so in respect of the first part of the question, when the client is an 81102 fund, the portfolio manager or the investment fund manager of that fund is to ensure that the fund complies with the custodial requirements of 81102. So that part is easy. However, if you're a portfolio manager and you have a managed account client that's holding units of an 81102 fund, those units must either be held by a qualified custodian who can tell from its records that the managed account client is the beneficial owner of the units, or those units could be held by any party of the client's choosing if the units are recorded on the books of the issuer or the issuer's transfer agent only in the name of the client. So those units cannot be recorded in the name of the portfolio manager, even if it's a managed account client of yours. It must be recorded in the name of the client itself. So that question leads beautifully into the next question that I've received from registered firms. And essentially that one is asking for clarification on what does only in the name of the client or fund mean in respect of the exception for client name securities or units or funds. And the question itself was, can a unit of an investment fund that is registered in the name of a portfolio manager acting on behalf of a fully managed account be considered held only in the name of the client for the purposes of this exemption in 14.5.2 sub 7c of 31103. And so can the unit of an investment fund registered in the name of the portfolio manager on behalf of a managed account be considered to be held only in the name of the client? The answer is no. The units of the investment fund must be held in the name of the client, which could be an individual, a fund, or another entity. However, portfolio managers can purchase securities for a managed account by relying on subsection Q of the accredited investor definition that's found in section 1.1 of National Instrument 45-106 prospectus exemptions. So yes, portfolio managers, you can still purchase securities for a managed account by relying on on subsection Q of the accredited investor definition, but if you want to rely on the exemption in 31103 for client name securities or for units of funds, the portfolio manager cannot be the entity named on the issuer's books. The name of the client who is not an accredited investor must be recorded on the books of the issuer, or the unit holder register. And I know that you're getting a little bit concerned at this time. However, although the non-accredited investor's name will appear on the books of the issuer, the portfolio manager will still be deemed to purchase as principal. So the portfolio manager and the exempt market dealer, in this case, they must both keep appropriate records to demonstrate that the portfolio manager purchased the securities as principal in reliance on subsection Q of the accredited investor definition. So again, it'll be the client's names on the books of the issuer, even though they're not an accredited investor, but we can still have the portfolio manager be deemed to have purchased on behalf of the managed account, and we just need the books and records of the portfolio manager to be clear in this regard. I also, in respect of this question about what does only in the name of the client or fund mean, I got a question regarding who can hold physical share certificates. And so physical share certificates can be held by a law firm, a registered firm, or another party, again, if the securities are recorded on the books of the issuer or the issuer's transfer agent, only in the name of the client or the investment fund. Physical share certificates recorded otherwise are expected to be held with a qualified custodian. We're getting really close now, everybody. I know you've put up with me for a very long time. I think we just have 2 more questions that have arisen, and then I can pass you over to Scott. So the 6th question that has come up is, with respect to non-resident registered firms and their foreign clients, so firms that have their head office in a foreign jurisdiction, in respect of their clients that are also located in the foreign jurisdiction. But in order to discuss the implications and our expectations in this regard, I think we have to have a little bit of a short history lesson, and I promise it will be short. So historically, these non-resident registered firms have been subject to Section 14.7 of 31103, which we repealed when we implemented our new custody rules. However, under this old rule, these registered firms had to ensure that all client assets were held either in client name, with a custodian or sub-custodian that meets the definitions in Part 6 of 81102. So again, it had to be client name, or with a bank or a trust company or an affiliate of the bank or trust company under certain conditions, and essentially meeting the definition of Canadian custodian in 31103 or foreign custodian in 31103, except for IROC dealer member firms. However, Section 14.7 brings them back in and says these assets could also be held with an investment dealer that's a member of IROC. So the new custody rules are not more restrictive than what old 14.7 used to be. And in fact, I think that the new rules are more flexible in most regards. However, if it is a firm that has a head office in a foreign jurisdiction and they are dealing with clients that are not in Canada, and the only connection to Canada in respect of that relationship is that the firm also happens to be registered in Canada, well, I would expect that we would probably take a practical approach on a case-by-case basis. And so some of the things that we would consider would be whether there's a similar robust regime in the foreign client's jurisdiction, and if not, the firm should be able to explain why a foreign client is less protected than a Canadian client if that is the case. All right, last question, and this one's easy, and it's a good one. So essentially, Section 14.5.2 of the companion policy to National Instrument 31103 sets out that registered firms are to encourage the clients or funds to confirm that they're receiving account statements from their custodians, and as applicable, to compare those statements to the statements they are receiving from the registered firm. So the question came up, how does this companion policy guidance interact with the CSA staff notice 31347 for portfolio manager dealer service arrangements? I know, you're on the edge of your seat, but I already gave it away earlier in my presentation, if you can remember back that far. So the companion policy guidance uses the words "as applicable" to account for the unique circumstances contemplated in the CSA staff notice, among potentially other things. The companion policy guidance is designed for situations where 2 statements are being given and contemplates that there's an IROC firm or a financial institution custodian. However, if the registered firm meets the terms of the CSA staff notice 31347, that guidance, they can still operate under that guidance so that the clients receive a single statement from the investment dealer. Thank you, everybody, for your attention. I really appreciate it. Hopefully that was helpful. And now you get to have a wonderful presentation on the results of the recent CRM2 sweep that Scott Lasky will be providing to you today.
Thank you, Leanne. I'm going to go through the results of the CRM2 sweep our branch conducted. I'll identify the common deficiencies we found during the sweep. You should use this information to self-assess your own firm's compliance with the CRM2 requirements. We selected 10 portfolio managers, 5 exempt market dealers, and 15 firms with multiple categories of registration for the desk review. We sent the firms a questionnaire to gain a better understanding of their business and the client reporting process. The firms sent us their policies and procedures surrounding client reporting. We also selected a sample of clients and reviewed the client reports sent to those clients. We have sent most of the firms a deficiency report. We described high-level results of the sweep in the recently published annual report to Registrants OSC Staff Notice 33749. I'm going to go through some of the findings in a little more detail, provide examples where I can, and try not to be too repetitive of information that was provided in an outreach session on CRM2 in February of 2017. If you want more details about the technical requirements of CRM2, I highly recommend listening to that outreach session, which is available on the OSC's website in the Registrant Outreach section. One very common deficiency identified during our sweep review was registrants not having any policies and procedures surrounding client reporting, or the policies and procedures they had were incomplete or inadequate. Another deficiency identified was ineffective internal controls surrounding the preparation of client reports. An example was a failure of the registrant's review process to identify missing information on reports or statements sent to clients. Registrants need to have policies and procedures that cover all the various statements and reports that are required, depending on their registration category and other factors. For example, if the firm holds client securities. Over the next several slides, I will provide more details for several of the policy and procedure related issues we identified during our sweep. When a portfolio manager does not send out its own client statements because its client's custodian, the broker-dealer, is sending them a statement, it is our expectation that the portfolio manager has written policies and procedures to ensure it has taken the following steps. 1. The PM ensures that it does not hold any of a client's investments and verifies all investments it does manage are held at the one broker-dealer. 2. The portfolio manager confirms statements are sent to the client by the broker-dealer with the required content and the required frequency. And 3. The portfolio manager should verify, such as through reconciliations, that the content of the broker-dealer's statements are complete and accurate. During our review, we noticed several portfolio managers that did not have written policies and procedures detailing the steps they took to perform these the three items that I just mentioned. For more information regarding this topic, please read CSA Staff Notice 31347, Guidance for Portfolio Managers for Service Arrangements with IROC Dealer Members, or you can listen to the same outreach session that I just mentioned from February 2017, where that topic was discussed in great detail. We expect firms to have a valuation policy outlining the firm's procedures for determining the market value of securities that are reported to clients. We provided guidance on determining market values in CSA Staff Notice 31345, Cost Disclosure, Performance Reporting, and Client Statements, Frequently Asked Questions, and additional guidance. CRM2 prescribes a methodology for different types of securities, and the firm's valuation policies should provide details of how the firm values all different types of securities that are relevant to its business. For example, for investment funds that are not listed on exchange, using the NAV. For securities listed on exchange, using the last bid or ask price. However, many firms are using closing price to value securities listed on exchange. We stated in the FAQ that using closing price may be acceptable where there is an active market for a security. Firms must be able to demonstrate that the last bid and ask price and the closing price are materially the same. To do this, you need to be doing periodic assessments. We would expect to see some policies and procedures for how the firm does that assessment. When the security is not listed on exchange, the rules set out the following hierarchy to follow. The firm should first try to find published market reports or inter-dealer quotes. If the firm is unable to determine a market value using market information, we will accept a valuation policy that is consistently applied and includes procedures that assess the reliability of any valuation inputs and assumptions. If available, valuation inputs and assumptions should be based on observable market data or inputs, such as the market prices or yield rates for comparable securities. If observable inputs are not available, valuation can be based on unobservable inputs and assumptions. Things will be more challenging when it comes to the exempt market and privately issued securities. In the exempt market, it might be reasonable to conclude that the market value cannot be determined. Concluding that you cannot determine the market value of a security is not the same as concluding that the market value of a security is zero. However, we would expect that if the market value of a security cannot be determined for a prolonged period of time, that may be an indication that the market value of security should now be zero. Again, you should have policies and procedures that address all of these factors and how you would address them. If a firm is required to deliver the account holdings to a client under either Section 14.14 sub 5 or Section 14.14.1, it will also be required to provide position cost. Position cost information provides investors with a comparison to the market value for each security position they have open. The goal is for the investor to be able to compare what they actually paid with the security's current market value. To deliver position cost, firms can use either book cost or original cost. These terms are defined in Section 1.1 of National Instrument 31103, and the definition of whichever method you choose needs to be disclosed in the client statement. We are seeing many firms use the term book value for position cost. That was okay as long as they were explaining that the book value is either the book cost or the original cost, and were including the definition. As we said in the FAQ, the position cost reporting requirements are not intended to be the tax cost. Firms cannot adjust position cost to align it with the tax cost. If a firm also wishes to provide tax cost information, they may do so in addition to the position cost, as long as the differences are made clear to the clients. We expect registrants' policies and procedures to identify whether they use original cost or book cost and ensure that appropriate disclosure is provided to the clients. We also expect registrants' policies and procedures to describe how the registrant delivers cost position information to its clients. For example, if the information is to be combined with the client's statements. When determining position costs, requirements differ depending on whether the position was open before or after July 15, 2015. The rules also take into consideration whether the firm acquired the security directly for the client or if it was transferred to it from another firm. If you acquired a security directly from a client on or after July 15, 2015, you will know the cost. If a security position was transferred in from another firm and you know the cost, you can use it, but you don't have to. You can also use the market value on the date it was transferred. This allows you to track the value of the security since you started to manage the account. The firm's policies and procedures should describe the method used and ensure that the method is applied to client accounts consistently. If you use market value instead of cost, you have to include a disclosure in a statement that says that you have used the market value of the security position as of the transfer date and not the cost of the security position. For positions open before July 15, 2015, you can use 1. The cost of the security if you know it, 2. The market value as of December 31st, 2015, or 3. The market value as of a date that is earlier than December 31st, 2015, if it is reasonable for you to choose that date based on the availability and accuracy of the information that you have. Again, if you use market value instead of cost, you have to include a disclosure in the statement that says that you have used the market value of the security position as of the date that you chose, and not the cost of the security position. The firm's policies and procedures should describe the method used and the reason why a different method is used for certain accounts if that is applicable. Examples of where it might be reasonable to use a date before December 31st, 2015 for some, but not all client security positions open before July 15th, 2015 include where the firm uses the same date in use for 1. All clients or security positions that were transferred to a firm at the same date, or 2. All clients on the same reporting system if the firm has more than one reporting system. The following information did not arise from the CRM2 sweep, but I'm including it for completeness because some of you may be registered as investment fund managers or scholarship plan dealers. The requirement for an IFM to send a security holder statement to an orphaned account, one without a dealer of record, is not new. This requirement usually arises in temporary and very limited circumstances. The firm's policies and procedures should address how these accounts are identified, ensure that statements are sent to the clients when required, and that the statements contain the required information. An investment fund manager also needs policies and procedures to describe how it satisfies the duty to provide information to dealers and advisors. Scholarship plan dealers are also required to send annual statements that provide transaction and account holding information. The firm's policies and procedures should address that statements are sent to the clients when required, that statements contain the required information, and also ensure that the information in the statements is accurate. We also found during the sweep that for registrants that were required to send trade confirmations, some had inadequate policies and procedures in place detailing the requirements and processes surrounding those trade confirmations. Some examples of matters that should be covered by the policies and procedures are timing, who is responsible, and oversight of any service provider if that function is outsourced to one. The Registrant's policies and procedures should also describe the internal controls surrounding delivery of trade confirmations, such as reconciliations and reviews performed. In addition to client statement requirements, you are now required to send 2 additional annual reports to your clients: the report on charges and other compensation and the investment performance report. Some of the firms we reviewed had inadequate policies and procedures surrounding the requirements to send these reports, for example, the delivery method with the client statements, and deadlines, if not sent with the client statements, then within 10 days, and the internal controls surrounding their preparation, including review and reconciliations. Unlike the account statements, firms can consolidate more than one of a client's accounts into a single report, if the firm has the client's written consent. This means one report on charges and other compensation, and one investment performance report covering more than one account. If you decide to send consolidated reports, your policies and procedures need to provide guidelines around the production of those reports. As a quick refresher, the report on charges and other compensation shows in dollars what the firm was paid for the products and services it provided to its clients, and also any other financial incentives it may have received in connection with the client's account. There is no prescribed form for the report, but it must include the following information: operating charges, transaction charges, payments received from issuers or other registrants other than the trailing commissions, and information regarding debt security transactions. Operating charge and transaction charge are defined in Section 1.1 of National Instrument 31-103 and only include charges paid to the firm by the client. There is a discussion on operating and transaction charges in the companion policy to National Instrument 31-103. Payments received by the firm by issuers or other registrants also need to be disclosed. This does not include trailing commissions. Examples of these types of payments are referral fees or success fees. Trailing commissions are required to be disclosed as a separate item. If the firm receives trailing commissions, the report also has to include a notification explaining what trailing commissions are. The notification has to be substantially similar to the notification provided in the rule. There is a sample report in the companion policy of National Instrument 31-103 that you can use as guidance. We also noted during the review that some of the firms reviewed did not have adequate policies and procedures to identify the money-weighted rate of return calculation method used by the firm to calculate the annualized total percentage return on the investment performance report. Again, as a quick refresher, you are required to provide annualized total percentage returns using a money-weighted rate of return calculation method. No specific formula is prescribed, but you are required to use a method that is generally accepted in the securities industry. You are also required to include an explanation of what the calculation takes into account. For example, you could explain that under a money-weighted method, decisions a client made about deposits and withdrawals to and from the client's account have affected the returns. We do not expect firms to include a formula or an exhaustive list. Approximation methods such as the modified DEETs are not acceptable. Approximations can produce misleading results compared to the money-weighted return, and advances in computing capability make it unnecessary to use them. If you want, you can provide percentage returns using both money-weighted and time-weighted methods on the investment performance report. But if you do, we expect you to explain the difference between the two in plain language to your clients. If you use both money-weighted rate of return and time-weighted rate of return, your policies and procedures also need to identify how the time-weighted return is calculated. We also noted that some policies and procedures did not describe how the firm determined the deemed account opening date, when this was applicable to the firm. The rule does include some flexibility for the deemed account opening date for client accounts that were opened before July 15, 2015. Firms that delivered their first investment performance report to clients in January of 2017, covering the 2016 calendar year, they could use January 1st, 2016. July 15th, 2015 could also have been used. Firms could also have chosen an earlier date if the earlier date is reasonable based on the availability and accuracy of recorded historical market value information. As with position cost information, examples of circumstances under which we would consider it reasonable for a registered firm to choose a date earlier than July 15th, 2015 or January 1st, 2016 for some but not all client accounts included when all client accounts or security positions that were transferred to the firm at the same time, or all clients that are on the same reporting system of the registered firm if that firm has more than one reporting system. After inadequate policy and procedures, the next most common deficiency noted was inadequate client statements or reports, or registrants not sending statements when they should. Exempt market dealers do not typically hold client securities. However, there are a few circumstances when an EMD may hold client assets, for example, firms that deal with mortgage syndications. In these cases, the EMD must provide an account statement in accordance with subsection 14.14 sub 5 of National Instrument 31103. See the outreach session, CRM2 reporting to clients and portfolio manager IROC dealer member service arrangements in February of 2017 on our website for more details on how exempt market dealers may hold client assets. If an exempt market dealer does not hold client securities, it might still have to send accounts holding information to the clients under section 14.1 if the firm receives continuing payments, for example, trailing commissions. This will catch mutual fund dealers and some exempt market dealers who are receiving some type of trailing commission. Several PMs were not delivering the required client account statements because the client custodian was delivering statements. However, some of these portfolio managers had not ensured that they had met all of the requirements specified in CSA Staff Notice 31347, Guidance for Portfolio Managers for Service Arrangements with IROC Dealer Members, PMDSAs. I discussed some of these requirements at a high level earlier in this presentation, but for more details, please listen in to that February 2017 Registrant Outreach webinar on this topic or read the staff notice. We noticed some registrants that were only sending out consolidated account statements. Registrants can send consolidated account statements in addition to the individual account statements. However, they cannot send out only consolidated statements. As mentioned previously, unlike the account statements, firms can consolidate more than one of the client accounts into a single performance or compensation report if the firm has the client's written consent. However, we noticed some registrants doing this without having obtained client consent or combining accounts of different individuals within a family group. In some cases, clients request that fees be withdrawn from one account to pay for fees incurred by the client or the client's relatives in another account. For example, pay fees for a registered account out of the client's cash account, or pay for the fees of the client's children's RESP accounts out of the parent's cash account. This results in the appearance that no fees are associated with the account. Our expectation is that adequate disclosure be provided to explain why no fees are reported in these compensation reports. When we reviewed the registrant's performance reports, we noted that the reports sometimes were missing the information required, such as the definition of the total percentage return and other associated disclosure I mentioned previously. Another common deficiency was the performance information was not always presented in all three formats required, that is, text, tables, and charts. Often the information will be presented in 2 out of the 3 methods. I believe the idea behind this requirement is that not every client processes information the same way. For example, some people prefer visual presentations. Therefore, charts are easier for them to understand. Finally, disclosures accompanying performance information was not adequate. For example, because they did not explain the use and relevance of each benchmark that was presented to the client. That concludes our presentation today. The following slides provide resources where you can get further information on the topics we discussed. We'll now answer questions we received throughout the presentation, and feel free to send in more questions at this time. If we do not answer your question, we will try and respond via the email you used to sign up to the webinar.